Today's session is part of our ongoing efforts to empower people with knowledge necessary to navigate legal matters with confidence and clarity. It is my pleasure to introduce today's distinguished speaker, Advocate Sandhya. She currently serves as the president of the Tamil Nadu Anti-Domestic Violence Abuse Council and Aegis of Women's Indian Chamber of Commerce and Industry, an accomplished posh practitioner and is a passionate advocate for justice, gender equality, and legal empowerment. With a robust background in law, Advocate Sandhya brings both depth and diversity to her legal practice, combining advocacy, litigation, and public education. Her legal expertise spans a wide spectrum from family law and gender sensitization to consumer rights and financial litigation. Advocate Sandhya also regularly appears before various civil and criminal courts in the Coimbatore district, demonstrating her versatility and command across legal domains. In addition to her courtroom advocacy, she leads educational initiatives such as Posh Forward 2024 initiative. Her dedication to both legal practice and advocacy ensures that workplaces are better equipped to handle these critical issues. We are truly honored to have Advocate Sandhya with us today to shed light on such an important subject. Ma'am, the virtual floor is yours. Ma'am, you're muted, ma'am.
Thank you so much, Sankita, for the beautiful introduction. And I'm so grateful for your consortium for having me here once again. I'm so happy for taking a session forward today. Okay, can we start?
Yes, ma'am.
Yeah, the today's topic is understanding the legal procedure for divorce in India. So when it comes to divorce, it literally means that it is the dissolution of the marriage. So for taking forward the divorce, we have personal laws. The majority of the marriages and the divorce all are dealt with the religions. It is all based on the religions. So we have different personal laws taking care of the marriages and divorces. So when it comes to laws in India, we have several laws for different religions. Uh, for example, for Hindu laws, we are having Hindu Marriage Act 1955, and for Christians, there will be Indian Divorce Act 1869. Sorry. And for the Muslim Marriage Act, they have personal laws, and also for the Dissolution of Marriage Act, Muslim Marriage Act 1939. And for Parsis, they have Parsi Marriage and Divorce Act 1936. And if they are inter community, the couples are from the inter community, they will be dealt under a special marriage act. So we have different religion based laws for dealing with the divorce in our country. So first we will be going through the part of Hindu Marriage Act. So Hindu Marriage Act have certain conditions to be fulfilled for a valid marriage. So when it is a valid marriage, then the degree of divorce will be an easier one. Or else we will be going forward with the voidable marriage or void marriage, and there will be declaration of the marriages. So when it is a valid marriage, there are certain grounds when the divorce can be declared. So if we look into the act, section 13(1) deals with the grounds for the divorce. So there are several grounds basically which will be similar to the Special Marriage Act also. The Hindu Marriage Act, the grounds for the Hindu Marriage Act, and the grounds for the Indian. One second. Extremely sorry for the past. So we have the ground similar to the Special Marriage Act. If we look into the Act of Special Marriage Act and the Hindu Marriage Act, the grounds will be similar. So the common grounds, if we look into 13, section 13(1), if the respondent is committed into the adultery, that will be a valid ground. If the respondent is going under any mental or physical cruelty, then it will be a valid ground. And if there is a desertion between the couples for more than 2 years, then it will be also a valid ground for the divorce. And if there is a unsound mind and communicable diseases, and if the respondent has renounced the world and has not been heard for 7 years, and the cohabitation was not taking place for the between the husband and wife for more than a year, then there will be a declaration of judicial separation. And then even then they are not going into the cohabitation process, then they will be going forward with the degree of divorce. So these are the common grounds under Hindu Marriage Act for the persons taking forward for the divorce under the courts. So when it comes to divorce, there are the grounds that I have stated now is are the grounds which are for the contested divorce. We have the practice of having a mutual consent for divorce also. So in India, there are two types of divorce. One is contested divorce, and another one is mutual consent. So in this contested case, one party will be the against for the another party. It may be husband or the wife, both can be the petitioner or the respondent. It will be open to both. In certain personal laws, only wife can seek some declarations. In certain for example, in Muslim law, in Kula, they will be that person will be having the right to take the divorce. And not in the Hindu Marriage Act, there is nothing like that. Both wife as well as the husband has the right to uh, take the contested divorce forward before the courts. So when it comes to mutual consent, everything will be settled within the parties. They will concludedly state that it is an irrevocable breakdown of the marriage. That word is so important in this mutual consent. The court has to be convinced that this marriage is not going to work at all, and it have come to the stage that it is irretrievably uh, break down to marriage. And if the court is convinced with that fact, only then the mutual consent will be granted. It is not like the media saying that the increasing divorces are so casual and they are going today and overnight they are getting divorced. Not the procedure is not like that. They have to mandatorily go through 6 months of cooling period, because the court believes that having that sort of period will convince the couples to get into a point that they may get compromise or may not. That is not with the hands of the court. At least the time may change the couples, and they will have something to think about it. So they are having the 6 months of cooling period. But even then in recent Supreme Court guidelines, the cooling off period can also be waived off. And for that they can take forward a separate petition for waiving of the cooling off period. So that will go undergo a process of having the inquiry. And even then the court is convinced that waiving of period, the cooling off period is not at all essential, because they have themselves declared that they have the strong thing for the marriage to get separated, and they have no idea to continue at all. Then that waiver petition will be permitted, and that 6 months also will be reduced. So then they will be moving forward with the mutual consent process. And if everything is settled, and the mutual consent will be, that is not also a one day overnight process. It will also take some time to 1 to 3 months, and more than that in many cases. And that waiving of period is a crucial period they have to undergo. In my opinion, that may uh, give a some breathing time for the couples to sit and settle, to think about them and their family. If child are involved, uh, their future will be also be sorted somewhat. And this is the process for mutual consent divorce. In that mutual consent divorce, everything will be settled. What are the properties they have to be jointly owning, or what are the amounts in the joint account, for example, in their bank accounts getting separated, who is going to take care of the child and who is going to bear the expenses of the child, and everything will be sorted and settled, and they will be declaring that it is an irretrievable breakdown marriage. So this is the process of mutual consent process. And for the contested process, either parties will be contesting. If you see the petitions of, I guess most of them are law students, and I'll be telling that the petition of the divorce for the contested one, it will be either will be husband versus wife or wife versus husband. In the mutual consent, both parties will be the petitioner, and it will be versus nil, because they both are the petitioners before the, it will be called as a joint petition before the court. So in contested petition, it will be either wife versus husband or husband versus wife. And in the mutual consent petition, the parties will be the petitioner only and versus nil. This is the point you can note. For any law students, it will be useful. And which code we have to approach, and obviously everyone know the jurisdiction lies specially with the family codes. If the or in many cases there are civil courts handling the cases where lack of special courts. But in majority of the India, the most of the family cases are uh, fixed to the family courts, that is the special court fixed for the handling of the matters of family matters. And divorce will be having the jurisdiction based on the where the petitioner resides. And that will be handled in like if the respond there is a thing in Hindu Marriage Act. If the respondent is the wife, then she can take forward the petition into her area. She can file a petition to transfer that to her area, because this gives a convenience to her to proceed the case under her flexibility. So the civil jurisdiction stays with the family courts, specially recognized for dealing with the matters of divorce law. And when it comes to Hindu Marriage Act, who is going to file the petition for divorce? And one who is aggrieved. Here, aggrieved can be, as I said earlier, it is wife, either wife or husband, both can do. If there is a simultaneous petition, then the earlier one will be dealt first. And according to the petitions, if they have applied for any transfers, then it will be transferred according to the, they will also go through an inquiry whether it is this place is good for the respondent. For example, respondent is a wife and she is having a baby. This will be a difficult part for her, so that will be considered by our courts. So for that they will transfer the cases also. But the petitions, whenever the petitions for miscellaneous petitions are filed before the courts go through all the facts and circumstances and then give the orders accordingly. So this is not that very easy that we file a petition and it will be um, going to have an order overnight. Every petitions is going to have a very strict inquiry considering all facts and circumstances. So moving forward for the um, moving forward with the Muslim Act. For Muslim Act, we have dissolution of Muslim Marriage Act, and also in certain cases, personal laws also been recognized. So in Muslim law, there are certain sections that we have to look forward. Mm, in case of Muslim law, the personal laws like recognized as kula and talaq. As we already know, talaq, triple talaq was held as unconstitutional in 2017, and it is also penalized in the year 2019. Because just like that, triple talaq is uh, fully given the rights to men. Only the Muslim men can give the triple talaq. For your convenience, the talaq is the word used to they have to pronounce it for 3 times, and then don't have to give any valid reasons also. If they are going to pronounce triple times the word talaq, it it is considered as a divorce. Then the husband is very free to go forward with his own life, separating his wife. So this is the process before 2017. But after this 2017, when it is declared as unconstitutional, the courts have gone through it because to protect the rights of the women. Just like that, her husband have the right to say 3 words, and then going to separate her life, and then he is going to move forward with this life, is not at all fair for the Muslim women. And the court considered this point and declared triple talaq as unconstitutional. And some practices are also going through this triple talaq also, but if they are doing that off the record, that is not going to be a valid one. But in the practical practice, I think that is also going in the process, but that is not a valid one. um, for the practices that is very backward, that is the process is very suppressing for the Muslim women. Many uh, protests were also have taken place in our history, and then it came to an end in 2017. And the Muslim Women Protection Act 2019, in that they have penalized this triple talaq. So, what a Muslim can do if they want a divorce, they can approach the court based on the Dissolution of Muslim Marriage Act 1939. They are free to go with this statutory provision alone. And there are also certain procedures that is also recognized under this act. For example, talaq-e-tafiz and kula and mubarat. Mubarat literally means the mutual consent. Mutual consent, where we have seen in Hindu Marriage Act, that is the replica of this Mubarak. In this Mubarak, they both can have a mutual consent given to each other, and they can also settle all these things, and they can get a declaration from the court. For that, they can file a petition to the court, and they can get a degree of divorce. And in Kula, only women are entitled to get an uh, divorce. For Kula, they have to have an agreement before the marriage or after the marriage. In this, only wife, that is the Muslim women, is entitled to get a divorce. And before this, if they are having a valid marriage agreement, they can also have a divorce also. In this kula also, they have to get a declaration from the court under this Dissolution of Muslim Marriage Act. So here the Muslim women also bound to give a valid consideration for the women. In Hindu Marriage Act, we will deal with the alimony and all, where wife seeks alimony from husband. Here the vice versa is the wife is entitled to give any valid consideration to the husband. And she can also have the right to, if she haven't give any dower, he can also claim that unpaid dower also. So the consideration she has to offer, and the husband has to accept that. She cannot offer something and later revert back. That is not allowed. She has to offer something, and the husband also has to give his full acceptance with the full consent. And then they will be filing a separate petition before the courts for declaring the marriage as irretrievably breakdown marriage, and they will get a separate degree of divorce order. And then next, they can go through talaq e tafiz. I hope I pronounce it correctly. And here there should be a pre-existing agreement. It should be before the marriage or after the marriage. That the agreement should be valid. That should have the already created conditions that if he is going to do so and so, and I'm bound to walk out of this marriage in a very acceptable acceptable uh, words. It should not be like overly imaginary things and all. It should be let's say it should be associated with the public policy. It should not be overly dramatized or something like that. If he is going to do so and so, and I'm going to get a divorce of separation from him. So, for example, we can say if you are having going to have a second marriage, I'm going to discontinue my marriage with life with you. This can be a one of the example for the uh, um, this talaq e tafiz procedure. And for this, they can file a divorce petition before the court, and they can undergo the process of inquiry and all, and then they can get the divorce. So this is the overall thing before the these are the procedures before the courts under dissolution of Hindu Marriage Act. So then it comes to Indian Divorce Act, wherein the Christians are dead. So this also resembles some of the grounds of Hindu Marriage Act also. So in Christian Act, they're all also having the grounds for adultery, unsound mindedness, and communicable diseases. And there are 7 years they are not heard and consummated with due to they are not consummated, and there is a willful refusal. And they can also sort a degree of divorce under when there is a restitution of conjugal. And for the sake of law students, you I hope you know restitution of conjugal rights. If not, it is a right to live with each other as a couple before the divorce process. That is a process, simple process of making the husband and wife live together again in between the divorce process. The court will order them to live together for a period of time. That is called as restitution of conjugal rights. And then even after uh, passing the degree of restitution of conjugal rights, the they are not complying with that, and there is a separation of no there is a separation between the husband and wife for more than 2 years. That is also a ground for the Christian divorce. And then the petitioner, when the petitioner and the respondent is separated for 2 years, that is we call it as desertion. When there is a separation and there is no cohabitation, that is called as desertion, and it is for 2 long years, then it will be also a ground for divorce under Christian Act. And the majority of the majorly used, overused ground is cruelty. Cruelty in any form. Cruelty, it comes to mental cruelty and physical cruelty. Both is a major cruelty ground. That is a major ground almost in our Hindu Marriage Act and in our Christian Marriage Act, and in also in Special Marriage Act. This ground is a very basic ground. If you are going to ask me, as a divorce lawyer, any divorce lawyer suggests this a ground, and the petition without a word cruelty will never be filed in any courts. So I don't say that is a very fake and creating something for the cruelty as a ground. But uh, here the courts also takes the cruelty under mental cruelty, any form of desertion or separation or anything that may create a mental cruelty. So many lawyers majorly use this ground, and as I said earlier, no petition will be forwarded before the courts without this ground of cruelty. To my knowledge, I'm saying, in my opinion, it's all my own opinion. And and these are the grounds, and based on this, also additional grounds such as, if the person, for example, that a respondent husband is declared as a guilt, as an accused for mm, rape or bestiality, then the wife is entitled to seek divorce. In these are the extreme circumstances, only when that guilty of rape is imposed on him. These are the additional grounds under the Indian Divorce Act. So also in this Indian Divorce Act, we can also seek for mutual consented divorce. Likewise, for the Hindu Marriage Act, we have seen here also they can seek. We have 13B section, and here we have section 10A. In this, they both can come to a settlement that we so and so are having these things going on with us, and we have come to a conclusion that our marriage is irretrievably breakdown marriage, and we have no means to live together anymore. And if they are going to prove that, then also they have waiving of period, and for that uh, for cooling off period, for that they can waive that cooling off period by having a separate petition, and that petition will be dealt first. And then if they are going to prove the court that this is not going to work, even they are going to give us 6 months of time, then if the court is convinced, that will be given an order for having a waive of 6 months. And then the mutual consent inquiry procedures will be going on, and then the declaration of uh, divorce will be given to them. So the process of having the similar uh, procedures will be very same when it comes to different acts also. But the thing is, the every process of uh, a process of having the divorce dealings will be going through a very hardship of time. And then we can say mutual divorce comparatively very shortcut for the divorce. But even then, having a cooling off period will be given to them for having a time, for some sort of time to uh, deal with that. But in recent challenges, recent changes of having a wave of will be will increase. Obviously, it give numbers to the successful divorce declarations in our country. So I think we have to deal with this in a very neutral way. We cannot say something like we can conclusively can't say that having a wave of period will uh, waiving of that cooling period will increase the divorce, and having a cooling off period will decrease the rate of divorce. That is not the true fact. In fact, some people, if they are the good thing that can happen to them is divorce, then this waiving of cooling period a will be a good thing for them. But for some people, like they can rethink their decision, or they are having kids, and the problem is not that much, or they can sit and talk and have a very healthy conversation and sort it out. If that is the case, then the cooling off period is very necessary. I think this differs from case to case, and judges have to be very careful on waiving of the period, of the cooling period, whether in whether this couple who can uh, settle themselves within themselves, if they are having a good period of time, uh, then they have to be given with that time. If that couple is also coming and having a petition before the courts for waiving of this cooling period, then that is not going to work. So I think it's all in the judge's hands. So it differs from case to case. Some people's only destinations, and they're going to escape from that hardship of the life, their goal will be the getting the divorce at the earliest. Then they have to be given with the cooling off period. They have to be given with the waiving of the cooling period. So it differs from case to case. I guess it all in the hands of the judges when it comes to giving a certain period of time to think or not. So when it then we can move forward with this Special Marriage Act 1954. It deals with the marriages and the divorces for the inter communities. For say, one person, husband will be from some religion and wife will be with from some other region. So in the inter community marriages, they will be dealt under the Special Marriage Act 1954. So, if, as I said earlier, the grounds for the divorce under Special Marriage Act and the Hindu Marriage Act will be quite similar. So, we can say under Section 27, the grounds will be similar to that of the Section 13(1) of the Hindu Marriage Act. You can literally see that committing of adultery and the desertion, as I said earlier, desertion for the period of 2 years, and uh, the major part of the petition, I said the cruelty is one of the majorly used grounds here also. And if the respondent has been committed an offense and he has been sentenced for 7 or more years, that is also a ground. And unsound mind and communicable diseases, and not heard for 7 years, and the cohabitation was not occurred for even after there is a degree of judicial separation or conjugal rights. Degree of judicial separation is not a degree of divorce. It differs from degree of judicial separation. They will be the court will be deciding that, let's say you both get separated for a year. That is called as degree of separation. And restitution of conjugal rights is the court will ask the couples to live together. So if they are seeking an order in either of these, and even after that they are having a continuous separation, they have not cohabitated for a year, then that will be a valid ground for a divorce also. This is an additional ground apart from the grounds that I have earlier stated. So these are the grounds, and these are the grounds. And also I have as I said earlier, one person will be contesting and another person will be against it, and in the mutual consent, both will be going to have a settled matters and going forward with the mutual consent divorce. This section 29 of the Special Marriage Act deals with the uh, mutual consent. So this is very similar procedure to the Hindu Marriage Act 1955. They will be, as I said earlier, they will be having the settled petition, and here also the parties will be petitioner, both husband and wife, versus nil. So apart from this, we also have the Parsi Marriage Act 1936. In this Parsi Marriage Act, the religion of people from Parsi alone will be dealt with this. And in this, the Parsi Marriage Act, the divorce procedure is also very similar, not very similar with the other acts. And only act that is slightly deviated from the usual procedure is the Muslim personal law. Apart from that, if you can going to see Hindu Marriage Act, Christian marriage, Indian Divorce Act, and Special Marriage Act, and the Parsi Divorce Act, Marriage and Divorce Act, overall overall the objectives and the procedures will be slightly similar. But in the Muslim personal law, it will be a quite different one, as it is based from uh, Holy Quran also. So that they have some kind of different procedures for their personal law. So here the also the grounds, majorly if you are going to see, unsound minors comes, and the cruelty comes very first thing, and the grievous, if the respondent has committed a grievous hurt to the petitioner, then it can be a ground. And not consummated for 1 year after the solemnization of marriage will be a valid ground. And here also comes the desertion of the petitioner with the respondent, either can be wife or husband. If there is a desertion, that is the separation between the husband and wife, not cohabitating for 2 years. And also there is no separation order by the courts. There is no consummation of the marriage even after 1 year after the order of separation was given by courts through any petitions. So these are the major grounds under Parsi Marriage Act, Marriage and Divorce Act, where the grounds are also very similar. So here also they can have a, a, a mutual consent divorce under section 13 to 32B. They So for once again for the refreshment we can see Hindu Marriage Act, that is 13B, and here for the Parsi Act it is section 32B. The procedures are all same. Here also they have the couples jointly, by giving a mutual consent, have to declare that they both entered into a marriage on so and so date, and they have lived for a quite long years till this date, and they themselves have concluded that this marriage is not going to work out, and the primary word that needs to be in the petition is irretrievably a breakdown marriage. So these are the overall um, laws that are dealt for divorce for different religion, people from different religion. So what will be the procedure? Will be the practical procedure? What are the documents going to be needed for them to file? That that is the crucial part as a lawyer, for a practical approach to survive in this, while dealing with the cases and all. So for proving the marriage, the very first thing we need is something related to marriage that has been occurred. We have to establish that every marriage has occurred with very valid witnesses, and we have lived for so and so long years, and now uh, we have this issue going on with us, and that is the ground. For example, if we are going to prove cruelty, we need some, if there is a police complaint has been filed or any witness, we have to bring that into the uh, petition, and we have to bring that witness to the court, and we have to proceed further for having the inquiry process and all that. So uh, for filing the for anyone under Hindu Marriage Act, to file a contested case or any mutual consent also, they have to complete a marriage life for at least 1 year. No person can be allowed to get a divorce if they are not going to complete a 1 year of marriage life. But in extreme cases where 1 year is can be seen through, and there is an extreme hardship is going on with that person, that may be considered in extreme cases alone, going through the facts and circumstances. Apart from the extreme cases, anyone seeking divorce needs to have completed a year, full 1 year of marriage life. Without that, courts are not going to encourage divorces also, because before that 1 year they will be a newly married couple, of course. For that, according to me, majority of the courts are not encouraging this type of filing of cases before 1 year. So majority of the courts only allow petitions if they have completed an year. So for the documentation purposes, any any person who is going to uh, file a petition needs to have a petition fully drafted with all details, with so and so reasons. Without that, without the valid ground, the petition will not be allowed. They have to uh, give the contents that satisfies the ground. So as lawyers, we will be drafting the petitions, and they will be going through the contents of the petition, and then they will be giving their verification also in that petition. The parties of the petition will also going to give the verification details, and then we are going to file the case before the court. So here, the parties alone is the parties alone is the parties going to handle the cases. So the presence of the petitioner is a must. The petitioner is them are entitled to give their petition on their own. They when they are going to file a petition, the court office staff will inquire about their name, their Aadhaar card details is going to match with them or not. They will be checking the original Aadhaar cards and details, their photographs and everything. They have to come in person to the court and file a petition before the courts. And uh, in many courts, e-filing also is being introduced, and if they are going to file it in e-courts also, but many courts are asking the petitioner, that is the parties, to come to the court in person and give them the fully prepared petition before the courts. So if a person is residing in foreign, they can't come. In the sense, they can give a power of attorney to a person trustable in here, and they can ask a permission from the court to allow him or her to, as a power of attorney of the so and so petitioner, to file the case and handle the case on their behalf. And that power of attorney should be a person with the knowledge of the marriage life of that party, who have given the uh, power of attorney to that person. So after that, the instead of that original party, the power of attorney will be taking care of the procedures. And even then, now with the technology and all, the courts are allowing video conferences and having a uh, video call for hearing the parties from anywhere. And courts are also being flexible with these things. These are the changes in the courtrooms that have occurred after corona, I guess. And now they are encouraging the parties to appear in video conferences also. but the process will be similar. On so and so date, they have to be compulsorily present, and the parties should give their fully inquiry processes, and they have to be cooperative even they are in online also. So these are the things that is regarding when one of the parties or in foreign countries outside, that is outside India. So for the Hindu, under Hindu Marriage Act, they have to give a the invitation at the time of marriage. That has to be one of the main document along with the petition. And then anything related to the the photographs that is related to the marriage, the occurrence of the marriage, that is also has to be submitted as one of the primary documents. Why these certificates are important is they have to prove that some jurisdiction will be based on the place of the solemnization of the marriage. So if we have to consider that, then the marriage invitation is required. So for that purpose also, and for telling the court that on so and so date the marriage has been occurred, we have to provide the invitation, copy of the invitation, and during the inquiry process and all, we have to show the original to the court. If in during the petition we can file a photocopy of that, and during the inquiry process we can show the court the originals also, and we can record it as an exhibit also. So these are the process, and the primary document is the invitation, photographs, and their address proofs, and identity proofs of both the parties. And to if we don't have the address of the respondent, the last known address will be recorded, and based on that the procedure will be going forward. Mm, these are the things very essential for the filing a petition. That is the first process of getting into the divorce. And then during the inquiry also, if we have any additional um, documents, if we have collected any additional documents to prove our ground and prove our side, we can also file it in between also. So then the petitioner will be filing the petition. Based on that, uh, it will be getting numbered, and then the first hearing date will be given to them, and based on that a notice will be served to the respondent. It may be wife or husband. And and after the notice of hearing was served, they have to file a proof of service, and then even then they are going to appear. Then they will going to contest the case, and if they are not appearing, a reasonable time for them to appear, and their uh, 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 for them to appear and contest the case will be given. And if they are with all means, if they are going to try, and the respondent is not appearing, then in having considering all the uh, time given, then the respondent will may uh, get an ex parte order, and then the petitioner will be favored of their prayer. They, if at all they are going to come and contest, the procedures will be going. Usually, the procedures, in my opinion, takes from uh, 1 year to three years, and in many cases, we can see the couples fighting for the cases for around 5 years also. So it differs from case to case. Not all cases go quickly, and not all cases take a time of 5 years and all. Usually, the period will be 1 to 3 years. And for the 1 year of period, I observe that that 1 year period will be very slow and will have a long dates. Judges have that type of practice, I guess. And after that 1 year, they will think that there is we have given an enough time for them to contest, and then they start giving some short dates and all for the hearing. So in that they will be if the petitioner is wife, then they will file a different kind of miscellaneous petitions in between also. And if it is for the husband, he will also file different miscellaneous petitions in between. So I think these IAs, we say IAs in IA interlocutory applications, that is being filed before this um, courts, that is the during the process of the divorce petition. And that petition will be taking some procedures. Again they will have to file a new petition in between. That is, I'm not talking about the main case will be stagnant there, and the new IA that has been filed will be moving forward with the inquiry process and orders and all. That will take us some quite time of the procedure, and that will lead to uh, uh, the time period for the main case also. So what are the IAs they are going to file? In case of husband, he will file for the child visitation rights. That is the majorly used IA, I guess, in the courts, because uh, husbands as a father, they have their own feelings for their child, and they need to see that child, but the mother, his wife, don't want to see make him see his child, and then she will not show her child to him also. And then this goes on a clash between them, and he will file a petition, and she will going to file a counter for that, why she is not going to say and all that. But in my opinion, family courts are very good to fathers also. And in certain cases we can see exceptions, but to in my knowledge, many courts are encouraging when fathers, that is the husbands, filing the petition to child visitations. They because I guess courts are uh, taking care of the values of the families. Though the husband and wife is fighting for their own case, child should not be affected at any cost. And I think courts are making sure the any no child is going to suffer during the process of the divorce. So these IAs or the I think these IAs sometimes or because of the egos between the couples, and she is going to file an IA, and he will also go file an IA, and this IA battle goes on apart from the divorce battle, and this prolongs the time for taking the divorce. And sometimes we can also see after an one year of period, they somehow themselves come to a compromise and they withdraw the cases also. So we can see different kinds of happenings in the family courts. One some For example, one couple will be extremely egoistic, and they fight till 5 6 years. And one couple we see, they will fight for a year and then get a they themselves get a compromise with themselves, and they will withdraw the case. And we can see different people around there, according to their life and circumstances they are living. They tend to have their own procedure for themselves up when it comes to divorce. So we can't say divorce is something bad that is happening to our Indian families. As I said earlier, in many people's life, if divorce is the only thing that they can have for a good in their life, that will be a safeguard for their life. But for some people, that may not be a giving some purpose for their life also. So it differs from place to place. We should not say divorce as a very bad thing. It We should, as lawyers, I guess, we should see divorce as a in a very neutral approach where it differs from case to case. So I guess it's been 1 year, 1 hour, and any questions I'm open to answer.
Uh, Thank you so
Hello.
much, ma'am, for that enlightening session. So now we'll move on to the Q&A
Hello.
segment. Uh, Someone is. Yes, sir.
Can I ask query?
Yeah, yes, sir. Yes, sir. You can go ahead.
Uh, uh, very, very good afternoon, ma'am. Basically, my query is regarding is that sometime the on the ground of the mental cruelty, the false allegations are made by the wives against the husband. In that cases, how to protect the husband from their allegations? Because this mental quality word is very wide. It's sometime it is used like that. Uh, uh, Father-in-law is saying something, mother-in-law is saying something, brother-in-law is saying something. In that case, it's very difficult for a husband to tackle the cases. Then how to deal that case?
That is a very big question, actually. As I said earlier, the cruelty is one of the majorly overused ground, according to me. No petition is being filed without the ground of cruelty. But as you said yourself, that that word cruelty has a wider meaning under the law. It differs from case to case, I guess. We have to file a very strong counter for that, and we have to convince. We have no other gateway to get into that, because only when we contest the case very strongly, and then we can have to fight that mental cruelty, and we have to break down that ground. In any way we have to think in that way. If you can give some example, as you said, mother-in-law is scolding and father-in-law is scolding. For example, if that person is living in a separate house, and mother-in-law and father-in-law is living in a separate house, that we can go file a counter very strongly, stating that so and so date they are not together. So we have to find the pathway. There is no other way, because for the court offices, if they are going to establish the ground, they will take the file into the case file. But as a contesting party, we have a huge burden of proving that we only have the right, and we do not go into that ground. So in any way, we have, based on the circumstances and facts given, we have to contest on no other go. We cannot get into that without this. And also judges are somewhat flexible, to my opinion, when it comes to mental cruelty. Nowadays they are also seeing that many fake cases are being, as we come across many sad events in these years. And we have to contest it very strongly, and as a contesting lawyer, we only have the power to save them also. And it differs from case to case, and we sadly have no other go than contesting and countering it very strongly. I hope I
Understood, ma'am. Thank
elaborated.
you. Thank you. Thank you, ma'am. Thank you.
Uh, Ma'am, the next question is not disclosing chronic kidney disease before marriage amounts to divorce. Cooling period not completed, will it fall under Section 14 of Hindu Marriage Act? Exceptions of Section 14.
So, for the chronic diseases, if the thing is only established after marriage, then it can be a ground for divorce. But we have to prove that it has been established to us only after the uh, marriage have been solemnized, and if it is already known to them, it was already informed to the petitioner, and then they have going forward with the marriage. And in that case, that will not be a valid ground for that, because the petitioner is already known of the fact. So what is your next question regarding exception something?
Yes, ma'am. Exceptions of section 14.
So exceptions of section 14, you're asking about Hindu Marriage Act.
Yes, ma'am.
Okay. One second. I'm just checking out that. So section 14 deals with exception. You're asking about the exceptions, right? So no petition for divorce to be presented within 1 year of marriage. Yes. This is the written rule in Hindu Marriage Act. As I said earlier, 1 year of marriage is a mandatory courts see. But in extreme cases, uh, this 1 year period is not mandatory, cannot be seen, and they go through the circumstances and the facts. If it is in extreme, if the person who is asking for the divorce is a petitioner that has not completed a year of marriage, can seek under this ground. One exceptional hardship that has to be proved. That is the only exception. The extreme hardship that even though the 1 year of the marriage is not completed, he or she is going through an exceptional hardship that has to be proved before the court. That is the only thing that make the courts to allow this petition. That is the exception. You have to prove that exceptional hardship.
Okay, ma'am. One of the participants has asked, under section 27 of the Hindu Marriage Act 1955, how can an husband prove during divorce proceedings that assets worth rupees 2.5 crore, though given to the wife, were handed over solely for safekeeping and not as a Sridhan?
So, the petitioner is a wife. She is having 2.2 crores of savings.
No, ma'am. Assets
What is the
worth.
question?
Should I read the question again, ma'am?
Yeah, can you please?
Yes, ma'am. Under Section 27 of the Hindu Marriage Act 1955,
Yeah.
how can an husband prove during divorce proceedings that assets worth rupees 2.5 crore, though given to the wife, were handed over solely for safekeeping and not as a Sridhan?
Okay. Why husband is going to give Sridhan to wife? I guess. Okay, if the question is like
Ma'am, there is also
he's like,
another question related to the same question. I'll read that out. In a divorce proceeding, how can an husband establish that assets worth rupees 2.5 crore, although given to the wife, were not her Sridhan but were handed over solely for safekeeping and
okay,
thus
I think
constitute joint matrimonial property eligible for consideration under Section 27 of Hindu Marriage Act?
okay. I think he or she is asking that the 2 crores, I guess, 2.2 crores, I guess, 2.2
2.5
crores of
crores.
okay, 2.5 crores is given with the wife, and that wife is now claiming that it is her Sridhan property, and now the husband is saying that it is his property that he has given for the safekeeping purpose or savings purpose. Am I understood right?
Yes, ma'am. The
If
person is
this is the
asking whether
question,
it is joint matrimonial property.
yes, if it is being deposited in any joint account, then it would be considered as a joint property account. If it is not, then if it is just kept in a house or in any unofficial record format, we that husband has the burden to prove that that whole money of 2.5 crores was earned by him and was given to his wife for saving the money. And if it is in any official records that they both jointly have, then it will be considered as a jointly owned property.
Moving on to the next question, ma'am. If the husband has offered money to wife and asks her to end the marriage, will that amount to an offer and mental cruelty under Hindu Marriage Act?
Yes, in many cases we can see just take this amount and go of this house, this matrimonial house, or some spoken by many of the husbands, and this creates some sort of cruelty in the wife's mental state. So, in if it is going to be proved in the court, then it will be a valid ground for the divorce also, because the duty of the husband is to take care of the wife and the family, and if he neglects that, and instead of that he offers an amount, that obviously creates a cruelty in the minds of the wife.
Okay, ma'am. The next question is, what are the chances for the men to win divorce cases? As we always see in most cases, decision goes in favor of women, or some sort of relief has been allotted to her immediately.
Why all questions are only related to men, I don't know. And whenever we speak of about the acts like domestic violence act and divorce act, always these question pops up, no wonder. And I think uh, the principle that husband has the duty to take care of the wife is the main idea of having this kind of judgments, I guess, because in we don't have the partnership kind of lifestyle here. There is a written rule or a unwritten rule. Husband has a duty, and he no other way escapes from that, and he has to take care of the wife no matter what. And if he fails in any sort of things, then divorce proceedings will be carried out by the wife, and her favor will be granted. So I think this approach based on the our society needs to be changed, because if you're we are growing, the women community in India, from Indian, are growing, and it is not touched this so far but we are growing somewhere. But we are imposing these indirect indirect duties directly to the husbands, that their sole purpose for having being a husband is to take care of the family, and he fails to bring the salary to the family, he will be uh, getting the he will be uh, going to give the maintenance to the wife. But if wife, they, in case of women, there is a options. Either she can be a salaried or earning person, and uh, or she can be an housewife. It is her choice. The option is given to women. But in case of men, they don't have any choice. They are given with the only choice that they have to bring money to the home at any cost. They should be the breadwinner at any cost. So in these cases, if they fail to do that, taking care of the family in a monetary wise or in any way, that creates a sympathy towards women, and that is also not an illegal thing or something like that. If you see the grounds, mental cruelty, through this we can prove the mental cruelty towards the women. So these are interlinked if we see it from outside world, and this creates sympathy towards women in many cases, I guess. And the prayers they have seek before the court will be granted in quite a easy way comparing to the men. So this approach needs to be changed, and now judges are also thinking of many different approaches. That will be sorry for the long answer.
Okay, ma'am. One person has asked two questions. The first question is, could you please throw some light on concept of irrevocable breakdown of marriage? The second question is, how can minimum prescribable period as prescribed in section 13B be waived?
Okay. Uh, for the first question, I think irretrievably a breakdown of marriage, that has to be either in contested case, has to be declared by the courts. The court has to come to a conclusion that it can, they both are not meant to each other. Separating them will do good thing to them. So in contested case, that has to be uh, declared by the courts. In mutual consent, that will be declared by themselves as a parties. So that is not a deep explanation. They decided themselves that that marriage is not going to work, and they themselves have no idea to take the marriage forward at any cost. So there is not at all a single chance or single moment for them to considering getting together is the thing behind the word irretrievably break down marriage. And the second question is regarding.
The prescribed period under section 13B, when it can be waived.
Okay. After if the couples have a solid 1 year or 1 or more years, they can have a court. The court will mandatorily have to give 6 months of cooling off period, and if the 6 months of cooling period can be waived off by filing a separate petition for waiving of the cooling period of 6 months.
The next question is, can women be given alimony if she's working woman? What is the difference between alimony and maintenance?
If she is working and her earning is proved, the husband may not be entitled to give the alimony. Only thing she can, if she is having a child, then on behalf of the child, for the child's expenses only, she can get an alimony.
Okay, ma'am, that's it with the questions in the chat box. Participants can drop your questions in the chat box if any. Tanupriya Singh, you have raised your hand. If you have any queries, you can ask, ma'am. If there are any else, if there are any other questions, you can ask. If that's it with the
Ma'am, I
question,
have one question.
yes.
Ma'am, I have that question. If the wife is earning, but can take her own expenses as well as that of child. So, in that case, the wife and child both get, or only the child will.
Your voice is breaking, Dhruv Vijay.
Yes, ma'am.
Your voice is breaking. Can you repeat the question?
Ma'am, my question is that if wife is earning and having a child, but the wife is not that much earning that she can sustain both her life and as well as that of child. So in that case, the maintenance will be granted to both of them or only to the child as.
It is based on the wife's salary, and the husband has the right to maintain wife and as well as the child. But if she is earning, that maintenance to the wife alone cannot be given, but he has the mandatory maintenance to be given to the child. He has to take care of the child at no matter what. Even though wife as a mother is taking care of his child, he has to give the maintenance to the child.
Okay, ma'am.
Okay.
If that's it with the questions, now we'll move on to the vote of thanks. Now I invite Selin Priscilla, the member of Tamil Nadu Legal Rights Consortium, to deliver the vote of thanks.
Good evening, everyone. I'm Selen Priscilla, a member of the Tamil Nadu Legal Rights Consortium, and it is my honor to extend
extend the vote of thanks on behalf of the Tamil Nadu Legal Rights Consortium and the Women's Indian Chamber of Commerce and Industry for today's insightful webinar on understanding the legal process of divorce in India. First and foremost, I would like to express our heartfelt gratitude to our distinguished speaker, Advocate Ms. Santhiya, for graciously accepting our invitation and for delivering such an enlightening and comprehensive session. Your clarity in explaining the intricacies of the divorce process in India, from legal grounds and procedural formalities to the rights and remedies available under various personal laws, has truly empowered our audience with essential knowledge, ma'am. The nuances you highlighted were both practical and and a special word of appreciation to our dedicated participants for your enthusiastic presence and engaging questions because it enriched the session and it turned into a great and dynamic learning experience. And we are very grateful for your time and active involvement. I would also like to extend our sincere thanks to our National President, Ms. Vaishnavi Murthy ma'am, and our mentor, Aishwarya ma'am, and the core members of the Tamil Nadu State Council for their unwavering support and guidance. It is through your shared vision and commitment that events like these continue to flourish and serve a meaningful purpose in the legal awareness space. A big thank you to our organizing committee and our ever energetic moderators, Ms. Sai, Nikita, and Bhargavi, for their seamless coordination and the scenes work to make this webinar a success. As we conclude, let us carry forward the insights we have gained today and continue to build a more informed and just society. Look forward to hosting more such enriching discussions in the near future. Once again, thank you all for being a part of this important dialogue. Thank you.
Thank you so much.
Thank you so much, Selen. Thank you everyone for joining us today. So the feedback form is shared in the chat box. Kindly do fill the feedback form. Your input is very, very valuable for us to conduct our future events. And kindly switch on your videos for us to take some screenshots. Thank you so much everyone for joining us today. So kindly fill the feedback form and you will be receiving your certificates in 2 to 3 days. Thank you.
Thank you so much, Bhargavi, Sankita, and Aishwarya. And some, I don't know the name, TNLRC, the person. Thank you so much for organizing and having me. Thank you so much.
Thank you, ma'am.
Yeah.